Good afternoon, everyone. I know a lot of the names on here, but what Mary and Carrie asked me to do here is to cover a handful of topics that are all interrelated regarding First Amendment issues as they come up in town governance and especially as it relates to the open meeting law. One set of issues I won't be covering is how these things apply to town meeting, which is, I see Carmen on the line, is an issue Carmen and I have talked about quite a bit and has a little bit of a different perspective because it's a legislative function. I may touch on that, but we're going to focus a little bit more on just sort of typical meetings, day-to-day meetings. So I just want to make sure everyone can see my screen, and then there's quite a lot of people. I may not be able to see you all at the same time. Mary, if somebody wants to ask a question that's in person, feel free to interrupt me at any time. Just chime in, and otherwise, if folks raise hands or something else, I can probably stop wherever.
Okay.
So let me just make sure I can share my screen here and do that safely without. Can everybody see PowerPoint presentation?
Come on, there it is.
There it is.
Right.
Yes, we can.
All right, great. Okay, thank you. All right, well, for those of you who don't know me, my name is Mina Macarius. I'm town council for the town of Concord, and I'm at Anderson and Krieger in Boston, and that's along with my colleagues, we run into a lot of these issues on a regular basis when we represent municipal clients. And in particular, I'm town council to Concord and Lexington, and in some ways, because of the symbolic and historic value of the town, there's just an extra sensitivity to these issues because I think a lot of groups look to Concord and Lexington as places where, if there is a First Amendment issue, if there's a constitutional issue, it is sort of paramount. So the first thing I'll start with is this idea of how the First Amendment applies and where it applies in town. So that begins with this question of what is a forum. Constitutional law around the First Amendment focuses on the idea of breaking down different kinds of public forums or public spaces based on their use and their traditional use, and the First Amendment applies in different ways to those. There are three basic types here. The first is a purely public forum. That's public property. It's open to public. It's open to public expression and assembly. A classic example is a street sidewalk or a park that is open historically, sort of at the core of First Amendment speech. There's also limited public spaces, and those are public property that's open to the public for limited purposes. A really good example, I give you an example here of a college auditorium used for a speaker event. Same would be true for certainly a high school auditorium. The library, certain public spaces in the library. Courts have also explained parts of airports or parts of other public facilities where there's another purpose other than speech or other than gathering that takes primacy over the ability to speak. And the last is a non-public property. So not all property owned by the town is considered public. Offices, places where business is being conducted by the town are not necessarily open to the public and therefore not necessarily open to public speech. There's a distinction between being owned by the public and being public property. With respect to public buildings, the biggest two categories really we're talking about here are public spaces and non-public spaces. And as I mentioned, the offices being the example of it. When you're in a public forum, again, think a sidewalk or a park, this is where there's the greatest protection for First Amendment speech, for free speech and assembly rights. The town can put and does put time, place, and manner restrictions they can put safety restrictions, but those have to be narrowly tailored to serve a compelling government interest. For instance, the town may allow signage on a public area, but it can't decide what kind of signage. It can't decide what it says, but it can protect for safety. It can protect for tripping hazards or sight lines for drivers. In a limited public forum, there is a little less protection for the First Amendment. Again, it's time, place, and manner, but now it only has to be reasonable and viewpoint and content neutral. For instance, using the library as an example, common sense ideas of what would work along with the public function of a library, quiet and study and perhaps limited meeting space, means that the town could disallow things like parades or politicking or campaigning that might draw more noise or more crowds. However, the town must still be content and neutral and viewpoint neutral. And one thing that is you'll kind of hear me say a couple of times as we talk about the First Amendment is that this is one area where the Supreme Court is actually in somewhat surprising agreement on a lot of issues recently. There are very few issues that the Supreme Court decides 9-0 these days. First Amendment issues are among those. And that is largely because there is an expansion on sort of the liberal end of the court of civil liberties, and on the more conservative end, a belief that there is no need to limit or distinguish between, for instance, religious or different types of political speech. So the reason I bring that up here is when we're talking about viewpoint and content neutral, that has come to extend not only to saying that a town may not decide, for instance, between two different political parties or different types of religion, but that if it's going to allow speech, it actually has very little limit on the nature of the speech and the content of the speech and the sort of the topics on which speech is happening. These are a lot of areas of nuance, but that's sort of as a broad point. Again, non-public forums have the least First Amendment protection. They only have to be reasonable. There are certainly anti-discrimination requirements, meaning that town can't decide who it allows into an office based entirely on protected classes, race, gender, etc. And it does have accommodation responsibilities, but there is no right to be in a private area of a town building. So the issue that I think, and I know some of you may have been at a prior training we did at the library, is around that comes up recently, and sort of one of the hot button issues that's out there is this idea of a First Amendment audit, quote unquote. So what is that? The First Amendment audit is not actually an audit of any official business. What it is, and for those of you not familiar, is it is private persons recording interactions with government officials, and usually for the purpose of posting on social media, with the thought that they will be, embarrassing or sort of calling out public officials that in their use of and sort of the conduct of their duties. And usually the folks conducting this kind of barge into an area and assert that they are conducting an audit under the First Amendment to their entitlement to record and to be in a place. And the first question is it legal? The first answer is yes, likely. The public is allowed to record public officials in public areas as they are undertaking public and official business. That is a limited right. It's actually, there's a case currently pending in the First Circuit, which is a circuit that applies to Massachusetts in terms of federal courts, that is testing just the limits of that. So it remains to be seen exactly how far. But it does not mean that there's unfettered rights. So what should a public employee do? And this is probably more for public town employees and town committee members in this case. But if someone comes into a town building during work hours and suggests that they're conducting one of these audits. The big advice we would give is stay calm and protect any sensitive people or information. There's no need to sort of make something that's private open to the public at that point. But remember that the purpose of this is to get reactions, and so to the best of your ability. And if this is sort of easier said for me, sitting here in a presentation and certainly in the moment, try not to react or to answer. You don't have any obligation to answer personal questions, sort of get into a back and forth with the person, or to invite members of the public into employee-only areas, etc. You could instead offer to speak by phone or invite them to come in another day if there is an issue that they want to discuss. And that would apply for potentially the person you're helping. Let's say it's at the clerk's desk. You may ask them, you say, this is happening right now. Would you like to come back another time, rather than do that? And then I think the other sort of big piece of advice is to use your judgment. If you feel that you or others might be put in an unsafe position, there is no obligation to continue to put up with that. The Concord Police Department has dealt with these before and has dealt with them well, and being able to call on help when needed is entirely appropriate. The town has also, for town buildings and the library, set up different policies for this. I would encourage staff to check with the town manager's office, but generally speaking, they follow some of the standards that we just talked about. Before I turn to social media and sort of how the First Amendment might apply there, we're covering a lot in one day. Any questions here?
None in the room, Mina. Are any online? No, we're good. We're good to go.
All right, great, thank you. And I recognize we're covering many topics at once, so I'm happy to take questions offline afterwards through others. And I see one of them is, will you address Zoom as a space? And we will actually in this later in the conversation.
Mina, we do have a question. Diane Proctor?
Sure.
Hi, Nina, and hi, everyone. I have a question, and I put it in the chat box, but if the school committee is holding a meeting in a school property, does it then become a limited public space because it's a meeting and therefore open for public comment, or does it retain because it's in a school building, does it remain it's a non-public with selective access? How does that get adjudicated?
Yeah, so it's a great question, Diane. We're going to cover a little bit later how these rules apply when you're in the context of a. I just want to make sure I'm actually still sharing just the PowerPoint, not the Zoom itself. We're in the context of a meeting, and the short answer is it really turns into a limited public forum at that point. In effect, what you're using the space for is the public function of holding the meeting, and there are rules applicable to how folks are invited to speak, and so that the business of the meeting can get done. So just because it's in a public space that might normally function in one way doesn't mean that it always functions that way. For instance, a private group renting a public building for an event, a concert or a presentation. I think I mentioned the college auditorium example. Just because it's in a public university, for instance, would not mean that it sort of would be treated the same way as an area for assembly otherwise. And in that context, as we're going to get to later in the presentation, there might be, the chair has a lot of control over how the meeting would run. So that there are distinctions there.
Thank you very much.
Okay. All right. So, in fact, I think since we're on the topic, I will come back to the sort of online world, and we're going to skip down to the open meeting law type comments, and then we'll go back up to the social media pieces. On under the open meeting law, and this is where these two things intersect. So Diane, to your point, when the school committee, in your example, or anybody is calling a meeting, there is a particular business of that meeting that is happening. And the open meeting law, in some ways, while it provides some restrictions on the conduct of the meeting, is also offering some guidance on how to address these First Amendment issues and these reasonable place, time, and manner restrictions. Some of the basics to review on the open meeting law for those of you who are newer to town government. All public bodies must post notice of any meetings, including an agenda. All meetings and all deliberations within them must be open to the public unless there's a valid purpose for executive session, in which case it's closed. And minutes must be kept for all meetings and published in a timely manner. What is a public body is effectively any board, commission, committee, most subcommittees, if they're created, elected, or appointed, or otherwise constituted. They might include advisory subcommittees, such as, say, a search committee of a select board or another body. They don't include, typically, town department staff meetings, working groups, informal working groups. This is a very tricky issue of when is something really a informal group and when is a formal subcommittee. In the interest of time today, and since this is not the main focus for today, I won't spend a lot of time on it, but generally speaking, the more formality and the more rigidity to the creation of the group, for instance, there is a tasked group committed to doing one particular function of the larger body, that's more likely to be a subcommittee than two people raising their hands and saying, yeah, I'll work on that project and report back next meeting. When they talk to each other, less likely to be considered a public body. Because of these rules, I'll just cover this very quickly. Again, the information sharing outside of public meetings is limited. There's a case, Bolter versus Board of Selectmen of Wayland, that clarified when sending documents, even across email, is considered a deliberation. And essentially, the court held that under the open meeting law, any circulation of documents containing opinions of members, even if there isn't a back and forth, if Mary sends something to the rest of the select board or to a quorum of the select board that expresses her views, that may be considered a deliberation. The SJC, this and also sort of to fix issues that might happen if they're posted simultaneously. So if in doubt, that's one way to deal with it. For your purposes of just having as a resource, other ways you can do this. This is where staff distributing materials that they authored as opposed to on behalf of a board member can be another way to make sure information is distributed beforehand. A board member might be able to distribute information that sort of comes from outside as opposed to sharing their views. The ability, as I said, to post or make public the same information simultaneously can also be helpful. But we would say in general, beware of email. If you're circulating drafts of a document via email or through platforms like Google Docs, or there could be a presumption of an open meeting law violation. So it may be worth reaching out to the town clerk or the town manager's office and asking for guidance, and as necessary, the town manager's office can reach out to us as well, or to the Attorney General's office, Division of Open Government. There are some limited exceptions to this. Of course, scheduling is often the most common one. It'd be impossible to meet if no one could ever talk about when to meet, so that the law recognizes that exception. So there are things like scheduling, what to put on the agenda, but again, carefully without expressing opinions. It's okay to say we really need to talk about XYZ project at the next meeting. Less okay to then add, because if we don't, we are going to fall behind and may lose funding, blah, blah, blah. So this is where I think I want to tie these two topics together here. So meeting procedures. The chair of a meeting of a board has the control of the meeting. And the chair is either the chair that typically presides over that body, but in their absence, it could be a chair for that meeting, an interim chair. The chair should be responsible for scheduling, for setting the agenda or helping to set the agenda, ensuring compliance with the open meeting law, including letting folks know if there's recording, if there's any special regulations for using Zoom, etc. And then there's this issue of how do they moderate debate. So a question was asked in the chat, and I think Linda, you asked it. I'm sorry, Diane, you asked a question with respect to how does the rules about public and limited public forum apply both in person and in Zoom meetings. And the short answer is that a meeting is required by law to be open to the public. So kind of regardless of the First Amendment, it is open to the public in that sense. It's a limited public forum in the sense that there is official town business or official business of that border committee to be done. That business is limited to the agenda, or in town meeting's case, to the warrant. So not anything goes at that meeting. However, there is a case from a couple of years ago that I know got a lot of attention called Barron v. Calenda about just what kind of control a chair can exert over a meeting. To give you the sort of background of that case, it involved a meeting where a member of the public who had had a long-running dispute with the particular board members started using harsh and defamatory, in a lot of ways, language about the chair. The chair cut her off, asked her to stop speaking. The case ended up making its way to the SJC, and one of the sort of big piece of it is that the open meeting law, isn't really the only limit here, but when someone is allowed to speak from the public, that you can again place and manner restrictions, such as when they speak, how long they speak for, whether they can speak while somebody else is talking. You can ask them if it's on an item that is coming up later in the meeting to wait for that point. But that does not mean, but you cannot and should not be trying to cut off somebody because of what they say or how they say it. The best practice from a legal perspective is to allow that time to pass, whether it's the 2 or 3 minutes or whatever you set as the time limit. Where folks get themselves in trouble from the public side is where a chair tries to cut somebody off because they determine somebody's comment was inappropriate or provocative or offensive, etc. I mentioned at the outset, this may be different for town meeting where the body's acting as a legislator and there's a bit of more control. It might be different for the chair in terms of maintaining control over their own board and board members. But generally speaking, the SJC has given wide latitude to members of the public to speak. Again, though, that is limited to when it is their turn to speak. Somebody coming up and shouting in the middle of a meeting or shouting over another speaker is not something you have to tolerate. That is something you can shut down immediately as the chair. If they are being disruptive enough that it warrants help or public safety help, to ask them to leave the room or to maintain control of the meeting, that's entirely appropriate as well. So it is not just a matter of letting, the law does not require free-for-all by any means. What it does require is that there is not a censorship of what is said and how it's said.
Mina, can I
Yeah, go
stop
ahead.
you? We have a question in the room. You want to take a question on what you just
Sure.
discussed? Great.
Yeah.
I'm Michael Williams.
Can you hear? Mina, can you hear?
A little bit. I might need you to repeat it, Mayor Bell. Try to.
Thank you, Michael Williams. A question and clarification. In Barron v. Calenda, is this a violation? Should content be the determining factor as to whether an individual speaks, is that a violation of First Amendment or a violation of open meeting law or a violation of both? Thank you.
So actually, what the case was decided on was on the Mass Declaration of Rights, so mirroring the First Amendment on the state side. So in some ways, neither, but it's really a violation of First Amendment and free speech rights on the state level, as opposed to the open meeting law. The open meeting law connection to it is actually the ability to the extent to which you could control it. Because you have an agenda, because the chair is presiding over the meeting, it's how this reasonable time, place, and manner restrictions align. In this case, is if this were to put it, to just put it by comparison, if this were the public sidewalk or an event on the town green, you wouldn't be able to necessarily have one person controlling when folks spoke altogether. But because you're in an open meeting under the open meeting law, you have a prerogative to follow your agenda, to use the time that you have, to limit speakers in that way. But what you still can't do, and that's essentially what the court clarified, is that right to control the meeting is not the same as it might be for someone to control a business meeting or a private meeting, and saying, that's enough, I don't want to hear anymore. There is still an element of First Amendment and rights under the Declaration of Rights in the Mass Constitution, in which folks have the ability to say what they want to say as long as it's within the jurisdiction of the body that's in front of them.
You have another question, Mina?
Sure.
Turn this on, maybe?
Yeah, go ahead, Jen.
I'm wondering if, somebody speaks up and uses very threatening language, you still have to allow that to go on, or can you cut that off?
It's a good question. It is not a bright line when you're talking about threatening language. Threatening language is not necessarily protected either under the First Amendment or the Declaration of Rights. In Barron v. Calenda, just to give you the detail, the person yelling at the select board member during their public comment period was referring to them as a, quote, a Hitler. You are a Hitler to the select board member. The select board member certainly felt threatened by that, but from a free speech standpoint, a court would not say that's threatening. There isn't an immediate, I'm going to do X, Y, Z. However, as a chair, and here's sort of what I think is just a practical piece, if you are in doubt and you're worried about safety, you're worried about a threat, while we certainly, as your counsel want you to be not infringing and not jumping over people unnecessarily, I also understand you need to use your judgment. And if in your judgment there is something's going to get out of hand and people might get hurt, that may be an appropriate time to do that, to cut that off. I also would add one thing that I think gets left out of a lot of the discussion about the Barron case is the court didn't really reach the issue of what the select board chair's rights were to respond. Because the select board chair cut off the debate and sort of cut off the speech, that became the focus. If instead someone had said something offensive, and threatening is a little different, obviously, because it may be more imminent, but if something offensive like happened in Barron, there is no bar on the chair or another member of the board asking to be recognized to respond. One of our clients had this happen in a meeting. Somebody came in, and it was more of a Zoom bomb incident, but it was, and we'll get to actual, sort of unannounced Zoom bombs, but where, a sort of prank actor raised her hand on Zoom to speak and then said very offensive things. The chair, in the moment, recognized, couldn't really cut them off, but what they did do is kind of establish that this was outside of the values of that town and outside the values of the organization by adding their commentary after. And while it's certainly not a perfect situation to have happen, you don't have to let the disruptive speech have the last word either. So that's another thing to keep in mind. But with respect to threats in particular, I think it's a judgment call. And if in the moment, you feel threatened, you're worried about safety, I think safety should be paramount. Just keep in mind that what might be threatening to one person in the moment may not translate to a court later as threatening if it was more in the line of offensive or bothersome as opposed to really worrying about someone's safety.
Amina, I have a question coming in from the chat from Vince Carlson. And he's asking, will the open meeting law be renewed by the legislature in March of 2025, now on the second extension?
Great question. I think you might be foreseeing one of my next slides, so we'll go right there. And we can also talk about Zoom on me. The short answer is I don't know, because the legislator has waited until virtually the last minute every time to see if it will renew remote meetings possibilities. And what I think, Vincent, your question is referring to, for folks who haven't followed this as closely, remote participation under the open meeting law has generally been allowed only when there were sort of personal reasons someone couldn't be there and the chair had to be in person, hold the meeting in person, and there were kind of a lot more requirements than we're now used to with Zoom and other features to be able to hold the meeting in sort of a hybrid fashion. Since 2020, during the pandemic, the legislature has allowed public meetings to happen remotely. I think there's a lot of debate out there about whether that's generally a good thing or not, but what I know there's less debate about, from local governments at least, is that it's a good option to have. There may be certain boards and certain times where you would like to have a meeting in person, and it's better to have in person, but certainly the option to have remote meetings has been incredibly helpful for things like being able to call a meeting during the daytime to address one matter, to have your town council be late and stuck in traffic and be able to speak to you remotely, for instance. There's a lot of advantages to it. So if I were, my prediction is that the legislature will probably renew it again, but it has come down to the wire each of the last couple of years, much to the chagrin of a lot of the groups that support local government entities like the Mass Municipal Association, the Mass Municipal Lawyers Association. Part of the reason for that is there's been a hope that there would be legislation that is longer term that replaces it, as opposed to just these part-time extensions.
You got one more question, Mina. Tracy?
Sorry, do I have to vote here?
I think so.
Grab that microphone.
Try this one.
Any of them?
Hi there. On a remote meeting, if you're having technological problems, like the link isn't working, is the meeting allowed to happen or not happen?
It's a good question. It is. It would be the same, I would say, as if you were in person. There are rules about, if the room can not hold the people that showed up, or the equipment that you plan to use doesn't work. If the meeting technology is making it so that the quorum of the board cannot hear each other or cannot communicate with each other, then you really can't go forward with the meeting. You're going to need to either adjourn, and whenever you have less than a quorum, that less than a quorum can adjourn to another time. You can try to suspend for a little while, take a break, and come back to fix it. If it's a hybrid meeting, and this kind of comes up more often, if it's a hybrid meeting where, let's say, the relevant board or committee is in person but is having the public join remotely, you are permitted to go forward. It is not an open meeting violation to go forward because there's still the in-person option. However, I think that's where a judgment call needs to be made about what's on the agenda and what you're going forward with. For instance, if you were going to have a public hearing on a permitting issue, either as representing a town, or if I was representing an applicant, I might be wary of having a hearing cut off midstream where folks couldn't get their word in, and then a decision is made. If people expected to be able to tune in and participate from home.
And then just one quick follow-up. If
Sure.
you don't have a quorum of the body holding the meeting, should you have the meeting?
I'm sorry, if you don't have a quorum of the
Yeah, if
body?
you don't have a quorum of the body, should you have the meeting?
If you don't have a quorum of the body, you technically aren't having a meeting. If that's not to make it,
Right.
a metaphysical issue, but you're technically not having a meeting without a quorum. So typically, what you should do if less than a quorum, fewer than a quorum shows up, is that you should declare that, and you might still want to take minutes that that's where you ended up, and adjourn to another time.
Okay, thank you.
And whether you can set it then or later.
Amina, a question from Nick Pappas, online.
Yes. It's the issue of official minutes versus a recording. And it is my observation that it's not uncommon for the written minutes to be questionable if you go back and look at the recording. And I guess the first question is, which governs? Has this been litigated or not? And what's your advice?
Yeah, so Nick, it's a great question, and it is one of the places where I think the open meeting law, even though it's been amended not so long ago, is already behind, because recording is so much easier than it was even 10 years ago. The short answer is the minutes govern. The minutes are supposed to be a summary of the meeting for someone who wasn't there to get the highlights. They don't have to be a transcript. I will say that in practice, as issues have come up about what happened at a meeting in different contexts, whether it's an appeal of a decision or a dispute over it later, it is becoming more common for parties to put into evidence the recording, a transcript, to refer to the transcript, to refer to the recording. It also comes up sometimes in the open meeting law as an open meeting law complaint that the minutes didn't accurately reflect what happened, and that is a much easier claim to make if there is a recording. But because there's no requirement for a recording, the minutes are technically the official record of the meeting. Everything, for instance, votes should be accurately reflected in minutes. But one of the things that I know has been thought about, I don't know if the legislature will ever do it, is to allow where meetings do have recordings, a lessened requirement for minutes, or to at least have the recording govern.
Is there any obligation on the town's part to maintain the recordings as an archival record?
Not forever. There is a retention schedule. One of the things that did happen during the pandemic is there was more of an emphasis on that maintenance. I think as that archiving, as it's become clear that it takes up a lot of space. That is the issue with the recordings. It takes up a lot of digital space. It's treated like any other public record. Typically, one of the things that, one of the sort of touch points is a recording should never be destroyed before minutes are made, if there is a recording. So that's one test. And then sometimes, if there, that is a question that we sometimes discuss with the clerk directly of, is it time to get rid of X, Y, Z? Are these old enough? Are there any need for particular minutes? Is anything in dispute, in litigation, on appeal, et cetera?
Thank you.
I got a direct question here, and I apologize, I don't know who it's from. Does a citizen have the right to slander other individuals, not public officials, such as select board members, that are either minor children or individuals who are not public officials, but just ordinary private citizens? And do chairs have a right to call the citizen out of order? That question hasn't really been fully answered by the court, and it's one of the things that worried people after the Barron case came out, is where is the limit to this? I think there's a couple of answers I could predict for you of what the answer is. One is that the chair might be able to call that person out of order in the sense that if it's off topic from the board or committee. One of the reasons the Barron case was as broad as it was is that it involved a select board. And the select board is a body with kind of a broad jurisdiction, so it's hard to have stuff outside of its jurisdiction. But there are some things, and certainly someone's reputation, a neighbor's reputation, is not something a select board needs to take up. And there are hints in a case that came before that against the town of Natick about that issue, where it was a trial court decision and then settled, but the trial court acknowledged that not everything is fair game in a meeting of a public body because it may not involve the jurisdiction of the public body. I think it is hard to believe a court wouldn't have more sympathy for a chair calling out of order somebody who is about to create a safety or security risk for somebody by disclosing confidential information about them, health information, naming their private children, naming the information that they didn't make public themselves. So I think a lot of the same kind of rule of reason would apply there too. And then of course, just because a chair may not be able to stop it during the meeting doesn't mean that there couldn't be civil liability for what's said during the meeting, especially if it's about a private individual, and it might not be deemed harassment or individual or violating the individual's rights that's being talked about. So this is not a free for all. And I would say that a chair that sees that something is I think you're probably on safer ground because it's likely to be off topic in the first instance. All right. I don't see any other hands up, and I apologize. I'm only seeing some of the chat for some reason. If it comes directly to me, so I don't know if there's anything else in the chat.
There's not.
Andrea, that I should cover first. Okay. Well, the last issue on remote meetings and remote or hybrid meetings is this issue of Zoom bombing, and I know this is a question that's come up, and I think there are sort of two kinds, as I refer to. There is the Zoom bombing that is an electronic, sort of disruption, comes in the middle of the meeting and tries to interrupt what's happening through it. In that case, towns or the chair in general have absolute ability to cut off what's happening, to disable that person or that entity that is trying to attack the meeting in that way and continue. Because again, it's a limited public forum at best that is trying to cover topics and go through an agenda. There is no obligation to tolerate that, just to be very clear. There's absolutely no obligation to tolerate that kind of behavior. It is, to the question earlier about quorum, it also might be appropriate to suspend the meeting at that point, to call a break at least, because there may be some cybersecurity issues if you're getting that kind of malicious attack. And often there's an associated piece to it. So I have no qualms about that. If it is someone who is speaking in their turn to speak, I think then the rules apply. I would say then the rules apply the same as if it were anybody else. If it is entirely off topic, or they're just making noises, or sort of just becoming threatening, there may be an ability to cut off their microphone. If they are speaking on topic but it's rambling, it's not, it's offensive, it's better to tolerate than the terrible 2 minutes of speaking time than to have to kind of litigate that issue later. But again, there are judgment calls to be made. I can't apply this to all situations, but that is not what I would consider a Zoom bomb. A true interruption of the meeting through a cyber attack, or trying to. We had a meeting once disrupted by. We knew who the person was, but they purposefully turned on multiple accounts and turned on all their microphones so that no one could hear each other. That's not something you have to be tolerant of. I see Ms. Manoukian, you had a question on filming meetings?
Yes, you said my name perfectly. Hi, I'm Julie. I'm the manager of Minuteman Media, and we are the TV station for the town of Concord. And we film all of these meetings that you're talking about today. So maybe we could meet separately and dive more into that. Sure. But when we talk about Zoom bombings and things like that, the rules we kind of go by for transparency for the citizens and residents of Concord is we have to air gavel to gavel. Mm-hmm. And, when you talk about Zoom bombings, and sometimes we wonder, is there appropriate times where we can edit?
Yes. Yeah. So I think as a legal matter, the answer is yes. Because as I was mentioning to Mr. Pappas earlier, the obligation is to create minutes, not necessarily recordings. So in those edits, what I would say, there are sort of a couple of different parts to this. I don't want to go too far off topic, but it's an interesting issue. The recordings are public records, right? And so the original recording itself might still be a record that you have to hold on to or should hold on to, especially if there's any investigation of where the Zoom bombing came from, et cetera. The editing for what you put out in the future for the meeting is appropriate. What we would sometimes recommend in those cases is to have, if it's possible technologically, something that makes clear that, you know, the reason you're missing minutes 55 to 57 is a Zoom bomb occurred and inappropriate comments were made, so we're editing that out. That's absolutely appropriate. That's sort of in your broadcast right, actually, of what you broadcast back. So you're not required to double down on the Zoom bomb by broadcasting it forever, but you may not be able to get rid of it in terms of a public records request or something else.
Gotcha, thanks.
And I should note that in general with recording, if someone else is recording the meeting, that they would have to ask for permission to do that. That will be granted. You have to grant that usually because you are in a public place, but folks can't just record meetings without asking. When Minuteman Media is doing it, usually the chair should announce that at the beginning to make clear that the meeting's being recorded. Okay. So the last thing I just want to cover on open meeting law issues before we come back to, and Mary, I know we have about 10 minutes. So I don't know how much time we have past that, or if we want to try to keep it all into the hour.
I think if you want to keep going and if people want to leave, that's fine. But if you
Okay.
can keep going, I'll be here.
Okay. All right. We'll try to get through some of these quickly. Well, the executive session issues are, these are, you know, the one thing that I sometimes hear is executive session is sort of an exemption to the open meeting law, and that's not actually the case. Executive sessions are part of the open meeting law. And I think the reason that's important is that they have their own procedure as well, and it is a procedure that is often one of the most complained of issues is when folks went into public session and how they did it. These are not, as it says on the bottom, not mere technicalities. So when you have an executive session, you need to convene first an open session. This must be on the meeting notice. It can't be sort of spontaneously during the meeting you realize you need an executive session. The chair has to state the purpose for it, and all subjects that may be discussed without compromising the purpose. So for instance, if naming the individual whose privacy is being protected during the executive session would compromise the purpose, you don't need to do that. But if you're talking about an item, ongoing piece of a real estate deal, for instance, and the other side knows that's what you're going to talk about, you should be listing and identifying it. There's, there are sort of different levels of confidentiality might apply. Before entering an executive session, you must take a roll call vote of all members. The two things on this, for remote meetings, all votes should be by roll call. So I think people have actually gotten more into the habit of doing roll call votes generally because we have more remote meetings. But certainly for executive session, all votes to go in and out of executive session and in it should be by roll call vote. I will say we also learned recently that the Attorney General has taken the position that roll call votes should be reflected in minutes by name, even when they're unanimous. I think that's a little bit silly, frankly, that, say there's 5 people here and all 5 voted yes, but you have to actually name all 5. So that's just another thing to keep in mind. It's a small but technicality. Executive sessions do require minutes, and part of that is to make sure that there's a record of that the executive session was properly used, that it was not used to talk about topics outside of what you said you would talk about. And the minutes stay confidential for as long as the purpose of the executive session lasts. In some cases, that's forever. For instance, attorney-client privilege. is one of the reasons that you may end up never disclosing executive session minutes, even after a piece of litigation, let's say, ends, because the purpose of the privilege is to encourage candor during the discussions, not just for that meeting, but for others. On the other hand, there may be particular policy decisions that fit under an executive session purpose at the outset, for instance, discussion of a price to pay for real estate, that no longer makes sense to maintain that detail once it's known what the town offered, et cetera. And so if that's the only detail you talked about in executive session, those minutes may be something that could be public. Again, it's a case-by-case basis. I won't go through them now, but these are the purposes of executive session. I think if you are in doubt, and if you're not familiar, if your board or committee has not used executive sessions before, I highly encourage, if it's your first time doing that, or if your first time for a new purpose, reaching out to the town clerk's office, or again, to the manager's office and asking to talk to us, because this is where, as I said, the bulk of open meeting law complaints to the Attorney General's office and to the courts come from. Is it is a time when, to the point made earlier, that you're not on camera, you're not being recorded, and folks have reason to wonder what's happening at the meeting, especially because most of the executive session purposes, as you can see on the screen, are times when there is some sensitivity, and so there's often somebody who's interested in knowing what's going on. They're the other side of the litigation, they're the other side of the real estate deal, the collective bargaining agreement. So this is attention to the finer details of executive session go a long way in preventing trouble later. Before I turn back to sort of the First Amendment, social media, and internet uses, any questions on any of the open meeting law coverage piece of this?
No, we're good. Oh, we do have a question. Sorry. We do.
Okay.
Questions to the propriety of open session, of executive session. Who's the arbiter when there's a question of whether executive session has been called for the appropriate purpose?
It's a great question. From a purely legal perspective, it's the chair can ask for a motion for it. The chair may have to declare, as you saw in some purposes. I'll go back to that slide. There are some purposes where the chair has to agree that there is a likelihood, for instance, of detriment to the negotiating position. So first of all, the chair has to think it's appropriate. The board or committee then has to vote by quorum and by roll call vote that they think it's appropriate. And there are times when members of a board say, no, I don't think we should be in executive session. That then, if they get it wrong, if they decide to go into executive session for a purpose and they overstated the connection, the nexus between one of these purposes and what they're actually talking about or what they plan to talk about, that can be addressed. The Attorney General's Office, Division of Open Government, has oversight over the open meeting law. There is a process by which folks can file a complaint with the Attorney General's Office if they think the open meeting law is violated. And the AGO has enforcement power under that to issue both, all the way up to civil penalties, although that is usually for intentional violations, but to require a meeting to happen again or to be corrected. There's also a judicial process by which a group of voters are permitted to go to court to challenge compliance with the open meeting law. So ultimately, a court could determine that an executive session was improperly held.
Thank you.
Okay. All right, so the other topic we want to talk about was sort of rounding out where speech happens in government. And obviously these are all topics we could spend a full day seminar on each, but just so I know we're running through these, is social media and First Amendment issues and websites and First Amendment issues. I think it's pretty obvious why these things are important now. Social media is widespread. A lot of folks live online. There is increased awareness of what's put online and who puts it online. And there is, I think, one of the factors that matters here is that with increased political and ideological polarization, what people say online is taken to be a matter of public concern more regularly, I think, than maybe at the beginning of the internet age or even 10 years ago. Towns have thought or have in many places put policies around this. And to do that, you need to understand the legal context of what you're trying to do and what you're trying to protect. Again, in the interest of time, I'm not going to go into detail on each of these, but part of this is a balance of figuring out, one, what are your ability to control board or committee members or employees' speech online? What are the implications of their speech? And what can you actually enforce? And also, what are some of the positive uses? The town website functions as a place of information. Town social media accounts provide information. And I think a lot more people turn to those sources now, before clicking on the local news to see, for instance, a snow day or, public service type announcements. So you don't want to limit yourself too much from being able to use these tools. As a legal background, one thing to keep in mind is the Supreme Court has determined that speech on social media platforms is considered protected First Amendment speech, that this is a forum for public speech. The cases have been becoming more frequent on this. Liking or disliking something, retweeting something is considered a form of speech. Public websites owned by a governmental entity may or may not be a forum for public speech themselves. And that, in a lot of ways, depends on what I was getting at earlier. The courts have been trying to adapt the physical world into the digital. And in this case, that means figuring out who controls it and what is the purpose of it. A account that is regularly used only for one-way communication by the town to put out information is not a public forum. That's a limited, it's a non-public forum. It's a matter of government speech, the town speaking for itself. On the other hand, a place where a message board that a public entity operates could be a public forum, or at least a limited public forum. I will just mention this test because it's been applied since, although it comes from the employment context. The Garcetti test involved later Mayor Garcetti of the city of Los Angeles and a local city DA. And it addressed the issue of, is a public employee speaking as a private citizen on an issue of public concern? And if so, does the employer, the public entity, have any ability to limit their speech? Most of the cases, I will say, around the country on speech issues within the public sector have come in these public employment contexts. One issue that hasn't been addressed as much in Massachusetts is how this applies to the many, many volunteer boards and committees, which are more common in New England politics because of our form of government than a lot of states have. I mean, there are some volunteer boards and committees, but there is a numerosity that is different in Massachusetts, certainly than a lot of states. But there is the case that I'll mention is sort of unpacking what exactly is speech and what is of public importance. Any expressive conduct intended to be understood to convey a message of speech. That's sort of been true for years. As I said, social media counts. And the question is, when do you know why speech was given? So there was a case recently that I'll just mention earlier this year, Linkty versus Freed. The case involved a city manager in Michigan who regularly, this was an elected city manager position, regularly posted on his personal Facebook page, both personal things about his life, as one does, but also things related to his job and to his role with that government entity. And the question, somebody, there was this person who was constantly putting messages that were unfriendly, let's put it that way, and somewhat mean to this person, over and over, kind of repeatedly dogging this public official on their personal page. That public official eventually blocked them and blocked them from posting. The question that went all the way up to the Supreme Court is was that speech protected speech or not? And the court came up with a test, or sort of reiterated a test, but put it in this context of when does a government official's speech count as speech that is official or private, and in turn, are they opening it up to the public to respond in a way that they can't limit the same way that we talked about with the Barron case, that they can't stop somebody from saying something they might not like. The first test is whether that person has actual authority to speak on the entity's behalf or the government entity's behalf. And the second is whether they purported to do that. If the person speaks as a private citizen on something that might be a public issue, but is outside their control. So, select planning board member, let's say, complains about, the budget for a school project. That's not really something within their control. Similarly, somebody who has a role and doesn't like a project next door and happens to be on some town committee or happens to be a town employee may have some protection for what they say about that project if it's something that they have nothing to do with. Whether that's an appropriate or a good thing to do is a different story, but we're just talking about the legality of it. And the second is whether they're authorized to speak for it. So are they speaking on behalf of the town, or do they seem to be speaking on their own? Again, very fact-based matter. And you'll see a number of factors the Supreme Court mentioned should be brought up. The topic, what's the person's job description? Are they speaking about something that's in their community versus national news? What's the tradition of using this forum? Are they posting it on the town social media account, or are they posting it on their own? Who's their audience? Have they kept their profile open to the public? One of the things that got this particular city manager, made this difficult is that their account was generally open to the public except when they blocked certain people. This was an issue, by the way, that came up and was not addressed during the first Trump administration with Twitter. As you had sort of the first president actively using a social media platform in that way, what does it mean if they no longer allow someone to follow them on their public social media account? There also was a related case came out at the same time, O'Connor-Ratcliffe, that raised a lot of the same issues. And in this case, I think the interesting part of O'Connor-Ratcliffe is this time it was a school committee, not employees. Elected school committee members. Similar set of facts, similar result, although the court decided more factual development was needed below. But the reason I mention it here is that this doesn't just apply to staff of the town. It may, in fact, apply to how folks use their own accounts, or if they are sort of mixing the two. So, what to consider then is, are you, and I will just, are you speaking on, if you are a person who is a public official, and all of you are in some capacity, to be really thoughtful about what you're using media for in ways that might be perceived as speaking for or as a public official, as opposed to as a private person, and really understanding the line between the two. And it can be very tricky because as public officials, you also have free speech rights. The question is, when is it okay to ask another board member, to ask a staff member to not do something? When is it stepping over their rights? That is a tricky issue. It comes into a lot of employment law. Again, I want to sort of touch at the high level. A lot of it has to do with what the state or the government entity's countervailing interest is. Courts have found multiple interests that are acceptable reasons for the public entity to limit speech of a public employee, of a public employee when it crosses the line. Some of it is in the efficient functioning of government. Where the employee is speaking, are they making it? Are they causing erosion of trust in the community? There's a case recently decided and involving the city of Cambridge, involving a police officer who made political comments on social media that the city questioned whether others in the city might react to as favoring one social group or another, and therefore disciplined him for it. And so far, the court had said that was okay to discipline him because of the particular role he had with the police department. It may be less okay to discipline a municipal filing clerk who doesn't have a public-facing role for making similar comments. So there is a judgment call there to be had. All right, so that is all I have, although that is a lot, and I appreciate the patience for all of it. And as I'll stop there for any more questions on this or any of the topics we covered earlier.
We have a question, Mina.
Yeah, thanks, Mayor.
Hi, Brooks Reed. When a town official or employee makes a public statement, is there an obligation for them to make only statements they believe are true, or can they say anything they want in that capacity?
So that is, Mr. Reed, that's outside the context of any of the open meeting law or First Amendment or any other requirements. If I think as a matter of good governance, public officials aim to speak and say what they believe is true and what they believe is right. Whether there's agreement on that is not something that can be policed by the law.
Thank you, Mina. Any other question? None in, wait, we do. We have another question in the room. Andrea.
Hi, I just want to make sure I understand about the open meeting law and the chair's responsibilities to allowing people to speak, which is if someone's in the room or takes their turn on Zoom and has 2 minutes to speak and just spews hatred or racist or truly personal insults, do you just have to wait it out for 2 minutes and then you can interrupt them?
It's a really good. It's a really tough question to answer because I think that the tricky part is in your question is the have to. The level of protection the law affords that person is pretty high. So in practice, the short answer is yes. If it's related to the jurisdiction of what you're doing, if it's entirely off topic, is a separate question. Then I think that then you might have to be able to stop it. I think the best practice based on the Barron case is to allow those 2 minutes to go through, as long as there isn't an immediate safety concern about what the person is saying. They're actually threatening someone in the room, etc. However, as I said earlier, I think that is a great opportunity, albeit an unfortunate opportunity, for someone to step in and say, for the chair or others to step in and explain that their reaction to that. I think that's entirely time. If you think that it was inappropriate to say, if you think it was cruel, racist, all of the things you just said, Andrea, that all of those things are fair game for the chair to say back. I also think it's fair game to remind folks that whether that's productive or not, or whether that's that's within the values of the town or the body or not. All of those things are fair game, but from a purely legal perspective, there is a strong level of protection for the ability to say those things in those contexts. Again, acting as a legislator in a town meeting may be different, but in that context, yes. And I think to Julie's question earlier, does Minuteman have to air it? I think that's a tougher question. In the moment, it might be appropriate to air it. Whether it's edited later, I think would be a question we probably have to think about in context of what it was. The answer is probably no for airing it, but you probably can't get rid of the record of it entirely.
Thank you, Mina. Any
Nothing else in mind.
no hands are raised? I see no hands raised in here. Thank you, Mina. Do you have
Mary,
any-
I see one more question that
Oh, you
came to me on the chat
Go ahead.
from Mr. Moore, and this was, is the town website a limited public forum? If we invite the public to share commentary with the framing that we should share it via the website or meeting packet, what room is there to curate or edit what is submitted? I think this is a tough question because it's a little bit dependent on what's already been said and the tradition on it on the website. If it is presented as, we will post what you say, there probably is less room to edit or curate. However, to the extent that there is any appearance that what is put on the website, I think what needs to be clear is if you're going to do that, is that this is a town acting as it does when it opens a forum of not regulating what is said. But if there's any implication that the town is the one speaking, then there's more room to curate. So I think this is it's a kind of a fact-heavy question, as a lot of these are, but that's it's a good one because I think there is certainly a possibility that leaving having a town website open for that could be considered a public forum. It's not a question that I'm aware any court has addressed yet, but it is related to the Linkty question in the sense of what was put on Mr. Freed's website. Or excuse me, social media page.
Anything else? Any other questions? Great. Okay. Thanks again, Mina. This has been really informative. It's very complicated. I'm glad we have you to sort it out, so all the details behind all this. So thank you for your time.
Thank you.
Thanks, Mina.